Attorney, your initial reaction to the arguments made to the presentation of Attorney Kaufman.
The defense have prepared well this presentation, and I think they have provided some arguments that prosecution would have to respond to later on. I think there were two arguments raised, but so far, 3 points were quite ethically argued by Kaufman. First is that when you look at the speeches made by the former president, his argument is that the evidence presented by the prosecution is selective. It's based on media reports, which are selective and did not encapsulate the full meaning of President Duterte. In fact, there are some exaltation and order or instruction to the police to only use force in the lawful exercise of the office, as a self-defense. From a legal standpoint, however, we will recall the presentation of the prosecution. They really presented a lot of the speeches. And during the defense presentation, they identified some of the speeches and qualified some of the speeches. And I think the judges might want to require to check whether the evidence is insufficient for the defense to explain all the speeches made. Because in the first 2 days, we saw a substantial presentation, different speeches where the president himself even owns up to the killings that happened and say that he's the one responsible. So on one hand, I think it's a valid legal argument to make. I do feel perhaps in the next part of the defense presentation and maybe tomorrow also, they would have to comprehensively respond to all of the evidence presented by the prosecution. That's one aspect that I think was emphatic. The second one, I think, is the argument against the issuances, especially on the Oplan, Tokhang, and high value target, double barrel. And they were saying that nowhere in the memorandum circular did the President Duterte order the killing. Only used the word neutralize, only instructed the police to exercise their functions in line with human rights obligations. So I think that was a very substantial presentation, and that was clarified by the defense. So I think the prosecution has to rebuild their argument, respond to this analysis of the defense. From a legal standpoint, again, I think we will recall that the prosecution presented eyewitness accounts where the police supposedly used force, even if the victims are not have any weapons or are merely with their families. I can recall the narrative presentation by the counsel for the victims. They did say that the police really understood neutralize as killing. So I think the defense has to respond to that more also, because so far they've just looked at the text of the policy, but the evidence presented by the prosecution on how the police understood it and how Duterte celebrated those deaths and killings, that has to be responded, whether later tonight or tomorrow. And finally, I think a very, very important point as well was their challenge on the absence of a common plan. They were saying that Duterte, the prosecution did not prove any or provide any evidence that Duterte was part of a common plan, meeting of the minds, no direct evidence to establish his pivotal role. At this point, I think the evidence they have presented, a lot of evidence.
All right, we now lost Attorney Yarcia there. I hope we can get him back while he's... Okay, go ahead. Go ahead. We got caught there. When you were talking about the connection, the common plan, the lack of evidence that would connect the former president to the killings.
Yes. Well, the defense said that there's no direct evidence or sufficient evidence to link President Duterte to the killings. And they were asking for the prosecution to provide some direct evidence or even looking at the circumstantial evidence presented and whether they're enough. We will recall and we have to compare this with the evidence of the prosecution because they did mention promises of impunity, financial support, promotions, a lot of supposed attributable acts for Duterte. And I think one aspect was addressed by the defense, but the judges may require a full response to each of the attribution arguments made by the prosecution. Those are the arguments so far, and our commentary and our reflections on the presentation of the defense.
With regard to, when we asked this, and you might have heard us asking this of Attorney Nery Colmenares before we had you on air, Attorney, no? Is circumstantial enough to take this case to the trial phase? Out of the pre-trial phase, sapat na ba ang circumstantial evidence para mag-proceed sa actual trial?
Yes. Actually, sa international court at sa international tribunal, at sa stage na ito ng confirmation of hearings, the only requirement is to establish substantial grounds. Ang ibig sabihin substantial grounds, sa minds of judges, it is reasonable to conclude that the crimes of murder were committed, that it's widespread and systematic, and that attributable to Duterte. Now, whether it's direct evidence or presentation of different circumstantial evidence, kapag reasonable na yung mga evidence na provide, it's concrete and tangible, that will be accepted. And it will not be a barrier than what was presented for those circumstantial evidence for the case to proceed to trial.
Did the prosecution make its case, present substantial evidence for it to go to trial?
When we were listening to the presentation of the prosecution for the first case, I do think that they had presented sufficient evidence if you compare it from the types of evidence that were accepted by the ICC in other cases. They were able to present a sufficient number of incidents where murders and attempted murders were committed to show that there are crimes of murder that are related to crimes against humanity. I think they've also laid down sufficient grounds to say that it was widespread and systematic and that there is essential and pivotal role for President Duterte as an indirect corporate or murdering or forcing people to commit the act. I would say though that the defense was able to bring out relevant criticisms that would put the presentation of evidence of the defense into a burden to rebuild their case. Kailangan nilang maipaliwanag, for example, bakit yung word na neutralize at human rights at lawful defense, ito talaga yung polisiya kasi kung may establish nila na walang criminal, common yan, then the judges might consider that one of the elements of the crime would be missing. And the absence of a single element required by the Rome statute would be sufficient for the case not to proceed to trial, or for the case, for the trial chamber to ask the prosecution to just conduct more investigation and not proceed to trial yet. But at this stage, tinitimbang natin, binigay na ng prosecution at the defense. Sa aking palagay, base sa mga previous cases, mukhang sufficient pa siya at this point. And there is still the task for the defense tonight and for tomorrow to still come up with stronger arguments to respond to all the evidence raised by the prosecution in the last 2 days.
All right. Well, we thank you for your insights, Attorney Edson Yarcia, Lee Edson Yarcia, who is a senior lecturer at the UP College of Law.